All right. Well, thank you for joining us today. My name is Jessica Groskopf. I'm an agricultural economist with the Center for Ag Profitability at the University of Nebraska-Lincoln. Remember to find an archive of our past webinars as well as a schedule of upcoming webinars in our Thursday series event on our website at cap.unl.edu. According to the Nebraska Game and Parks, 97% of the land in Nebraska is privately owned, so obtaining access to private lands is one of the biggest challenges for hunters. Leasing the hunting rights of agricultural land can generate additional income for landowners. However, some landowners are hesitant given the potential liability. Today, we will cover Nebraska recreation and agritourism laws and review ways to mitigate this liability. We will also discuss working with multiple tenants and developing hunting lease agreements. With me today is Dave Aiken, a water law and agriculture specialist with the Center for Ag Profitability. Thank you for joining me, Dave.
Glad to be here.
All right, so we're going to go ahead and hop on in to the discussion of hunting leases. And again, if you have any questions, if you would please put those in the chat or in the Q&A. Both Dave and I are happy to answer those as we go through today's webinar. So as we move forward, I would first like to start with recognizing that this material is grant funded, and we would like to thank the North Central Extension Risk Management Education Center and USDA National Institute for Food and Agriculture for their support of this project. This grant that this presentation is a part of is a collaboration between Kansas State, Nebraska, and Purdue. So the first thing that we are going to discuss, and I think one of the most things that comes up when we start discussing hunting leases is the liability issue. There are two laws that govern liability for Nebraska in terms of recreational and agritourism use. The first law is the Nebraska Recreational Use Law, and that law applies when a landowner is not charging for access to their agricultural lands for recreational use. The second law is the Nebraska Agritourism Law, which then applies when a fee is charged for use of that agricultural land. So just to go through the statutes just a little bit more closely, again, when we look at the recreational use law, the state statutes are listed there, and basically what it states is that as long as the user of that property is not charged a fee, the landowner is not responsible for ensuring that the premise is safe for recreational use. So that's the first side of it. So if we're thinking about hunting and we're thinking about hunting leases, if we allow someone to hunt for free, we fall under then the recreational use law and do not, then we are not responsible for ensuring those premises are safe. The second law that is important if we're talking about leasing out those rights to others then becomes the Nebraska Agritourism Law. And this law requires that landowners either post signage or include a warning in any written contract between the owner of the property and each participant allowed on the premises for a fee. And there's specifications of how that written wording should be stated, and it should also not be written in less than 12-point bold-faced font. So on the next slide, I'm going to show you what that warning is. And the warning must be clearly stated as written in the statute. So here is the exact wording for that statute. I'm not going to read it out loud to you, but if you have a smartphone, you can use your phone and scan the QR code there on your screen. It will direct you directly to the state statute and provide you with that exact wording. Also, a recording of today's webinar, as well as our slides and some additional information, will be posted online after the webinar at cap.unl.edu, so you can obtain that wording. So often folks will ask us, You know, should we have the signs that contain the warning, or should we have a written contract? And the answer to that is it's probably best to do both, to make sure that the signs are posted as well as including that in the written lease agreement. So I'm going to pause here for just a second because I want to make sure that if there are any questions related to the two liability laws in the state of Nebraska, that they are addressed. So again, if you have a question, you can place it in the chat or in the Q&A, and Dave and I would be happy to answer that at this point. All right, I'm not seeing any questions come through the chat or through the Q&A, but again, if you have those questions, feel free to place them in the chat or the Q&A at any time during the presentation. So another way to reduce liability in this scenario is the use of liability insurance. And I think it's really important when you talk to your insurance professional that you are very clear that your property is being used for recreational use, whether that's hunting or other forms of agritourism, and that they are able to make sure that you are covered under your current policy, or if you require any additional riders. You also need to identify any exclusions, and this should be reviewed on a regular basis with your insurance agent. Liability coverage in this form is probably one of the most affordable ways, or one of the most affordable insurance options, and a great way to reduce your liability. There are some additional steps that you can take to reduce liability when you are leasing your property for hunting rights. The first would be to go out and to inspect your property for safety hazards, and if possible, remove or repair any of those hazards. Plan for an emergency. I think this is something that sometimes we forget, but especially if you are in a rural area, please make sure that you have emergency supplies available, that you have a written response plan if something happens on your property, and that those on your property are trained to handle emergency situations. We already discussed your liability insurance policy, and again, we encourage you to review, purchase, or modify that on a regular basis. The next one that we're going to get into, and I think is extraordinarily important, is to have an attorney write a lease agreement and or a liability waiver for your use. Use the information from your inspection to provide folks coming onto your property with a written warning of those dangers. Also include the Nebraska warning statement, and then have them signed and notarized. We already talked about the warning signs. You can have those posted as well. And then the final thing that you can do to reduce your liability is to keep records by documenting your inspections, posting your signs, and dating when those signs were posted, and also keeping records of any safety trainings that you have done. So let's talk about now the hunting rights. And often when you hear the Center for Ag Profitability discuss hunting rights, we talk about it in terms of a cropland or a pasture lease, and we talk about the landowner and their tenant in terms of their farmer or their rancher. But really what we need to be talking about as we talk about leasing hunting rights is the possibility for there to be the landowner, and then potentially multiple tenants that are now involved in this property. And so it's really important to identify which of these people currently has the hunting rights. So as we talk about leases, it's important to note that in Nebraska, if the cropland or pasture lease does not, in Nebraska, if that property is leased, the landowner does not automatically retain the hunting rights. Okay. So if within the lease agreement, if you have not specified that you as the landowner are retaining those hunting rights, you have essentially given that tenant the rights to the hunting for the duration of the lease, as well as the ability to sublease those rights to others. So it's really important as we think about this, especially as we're getting into deer rifle season here in a week or so, that you understand you may have potentially allowed your current tenant who's farming your property to have those hunting rights. So when we talk about this, it's really important that we go to our current existing leases and we think about how they're written. So for farmland and pasture leases, as a landowner, if you would like to lease those hunting rights to others, you need to explicitly or for specific seasons retain those hunting rights. So here's an example. If I have a farmland lease, I can simply state in there that I, as the landowner, retain all of the hunting rights. Another example would be I only retain the hunting rights for deer rifle season, and that tenant could then potentially hunt for other season. There also needs to be a discussion on it could be that you have approval of rights. So getting that tenant getting approval to hunt for specific seasons or for specific dates. And then there also needs to be clarification on subleasing. I think one of the complaints that we often hear from landowners is the subleasing of hunting rights causes tension within a farmland or a pasture lease. So can that tenant, if they have those hunting rights, then sublease either to their neighbors or their friends or their cousins or other third parties? Something that really needs to be clarified within the farmland and the pasture leases. So I did want to share a couple of examples with you. And these are from aglease101.org. Again, you can scan the QR code with your phone if you would like to see these example farmland and pasture leases. And this is how they worded the retention of those rights within their farmland or their pasture lease. So in the top example, under recreational use, this is one of those approval statements. Recreational use of the property must be approved by the landowner in advance. And then the bottom one kind of deals with the sublease issue. The owner does not convey the operator the right to lease or sublet any part of the farm or assign the lease to other persons. So again, just really clarifying, if you're going to have multiple tenants, making sure that you as the landowner have retained those rights and you've clarified, especially on those farmland and pasture leases, what is expected of that tenant and what they do and don't have the rights to do as your farmer or your rancher. So again, even before we get to the hunting leases, we need to be very clear with the farmer or the rancher on our property whether or not they have those hunting rights or whether you as the landowner have retained control over those hunting rights. So once we've clarified that, now is our opportunity to discuss hunting leases as a separate, basically, enterprise or a separate lease agreement. So there is an example hunting lease and checklist that is available. Again, you can scan the QR code. This is from a publication called the Ranchers Agricultural Leasing Handbook, and it was out of Texas A&M. I will warn you that this is not a Nebraska specific lease agreement. So we still encourage you, if you are going to lease your hunting rights, that you have a Nebraska attorney draw up a lease agreement that then encompasses the warning that we talked about earlier and provides you with that additional protection required by Nebraska state statute. So this example also has a checklist that goes with it. I would encourage you to look that up. I created a Go URL there so you can get to it more quickly, and I'll show you that document here in just a minute. One of the things it does do, and I think is important to think about, are what should be included in that hunting lease and what are the basics. Obviously, the names of the parties included in the hunting lease are important, yours as well as whoever you are leasing to. The dates of the lease, when can they enter, when do they need to be off the property. Something that was really important, and I think sometimes we forget, is not only just the description of the land, but maybe potentially including a map of that property as well as the access point for that property. Where can they enter and exit it? The next kind of grouping is harvest provisions. So what types of game can they harvest? Are there any limitations to that game? And then what hunting methods are allowed? And finally, cleaning and disposal of the carcass. So having that listed out within the lease agreement. The next piece would be the price. So the payment method, the due dates, and potentially a security deposit if that's something that you're interested in. Something I thought was really interesting was a no guarantee of success clause, and then of course that release of liability. Getting deeper into the provisions that you might want to consider are the use of vehicles or ATVs, any use of facilities on the property. So if there's something there that they do or do not have access to, and making sure that's clearly defined. I thought it was fun to keep a clause in there about keeping gates closed. Something that's really important is the number of hunters permitted. So again, addressing guests of the leasee, the number of people, but then also whether or not they can then sublease as well from their lease agreement with you as the landowner. I think this is really important. The right to put up improvements on the property, such as deer stands, blinds, pits, or game cameras, which I think would be really important to define, and then also discussing removing that property. And the final one that I pulled from their list was damages to the property. But again, you can find a comprehensive list on that grazing handbook. And I'm going to just pull this over here. So this is their example lease agreement. It starts on page 75 of the PDF. Again, it's kind of a fill in the blank opportunity and goes through a lot of the details that I just covered in those past two slides regarding the checklist. Again, this is an example. It is not Nebraska specific. We highly encourage you to work with an attorney to draw up the appropriate document then for your property. But you can also see that example there at that Texas AgriLife link that was provided. And again, it looks like the slides will be posted by noon tomorrow in the archive section of our webinar page. So the final thing that I think is important as we're drawing up these lease agreements is to think about the fact that if you have multiple tenants on your property, those tenants might have different priorities, and to make sure that those tenants are aware of one another and aware of what might be happening. I'll give you a perfect example. Putting in a goose pit might not be in the best interest of the farmer, but is in the best interest of the hunter on your property. So thinking through some of those opportunities and exploring how you can make sure that those tenants are aware of one another and looking for ways to potentially resolve conflicts between the two of them. So making sure that that they're working together and they understand their relationship with you and their relationship with one another. One thing I do want to point out as we move forward is the Nebraska Game and Parks. The Nebraska Game and Parks has a really great website that provides the local hunting dates, and you can also download then from their website this nice card that shows you exactly what seasons are when. So again, this will be important as you're drafting a lease agreement to be able then to match your lease agreement potentially with these dates. So just another great resource for you. So at this point, I do see that we do have a question in the chat box, and I'm going to hold on to that one for just a minute as we discuss, just continue through the lease agreement process. So one of the questions we often get is, what is the price, or what is a reasonable price for hunting on our property? And the answer to that is it depends. And it really depends on the quality of the habitat, the species that are available, and then the length of the lease. So that's something that I think really we need to take into consideration of, are we working with just one person for one day, or are they leasing those rights for a more extended period of the time? So one of the things we need to think about with a lease length is that there are potential, if you do go into these longer leases, that there will be potentially a preseason that somebody might come out and want to scout for specific animals. There's the season, and then there's the postseason. And so thinking about the length of that timeline can be really important when you're setting up that agreement. So during each of those time periods, how long are you going to give them before the actual hunting season? And then again, if they provide improvements, tree stands, those kinds of things in the postseason, how long do they have to remove that property? So sometimes we think about maybe those really kind of short-term leases, but this could be something where it could be a longer relationship that you have with this person. Another consideration is whether or not that lease automatically renews, and again, or whether or not it terminates at the end of the season. So you need to think about those like you would with a cropland or a pasture lease on how you're going to set up that mechanism within the lease agreement. So although we don't have a survey that tells us what the going rate for specific types of leases are, we do have a few different ways to price hunting leases. So the first way is to do a break-even analysis for that hunting lease, and then look at adding some sort of margin on top of that. So the example on the screen is adding 10%. The second way is to do a habitat valuation. And again, habitat plays a big part in the potential revenue from that lease. So looking at what type of habitat you have available, and then pricing the lease based on the habitat. The next one is a baseline. So charging a base per acre plus any improvements. Asking around and competitively pricing your lease based on the going rate for other leases in the area. And the final one, which I think is really interesting, would be a sealed bid process where you would provide a description of the hunting lease and what it offers and request sealed bids. And that might give you an idea of what the property could lease for based on the description. But in that scenario, you would have to have a pretty good handle on the species, the habitat, and the size of area that you're interested in leasing out for your hunting lease. So I think it would be a travesty if we didn't talk about the fact that there are conservation programs available to assist you in building your wildlife habitat. we're not going to spend a whole lot of time on these programs just because, you know, the point was to discuss the lease agreements. But do know that there are options out there for you to improve the habitat that you have available. So there's really three big players in the discussion of habitat improvement. That includes the USDA, the Nebraska Game and Parks, and then nonprofit conservation programs like Pheasants Forever. So these three entities really are interested in developing wildlife habitat and are great resources to help you in improving that wildlife habitat. So I pulled a few USDA programs that I'm aware of. There could be more that help with, in particular, wildlife habitat development. So at the Farm Service Agency, that's the Conservation Reserve Program. And then at NRCS, it looks like EQIP, CSP, and Working Lands for Wildlife are the main three. But again, if you're interested in improving your wildlife habitat, I would encourage you to go to your local USDA and ask them about what you may or may not qualify for, and they can help you through that process. The last program I think is really interesting and should be mentioned is the Nebraska Game and Parks Open Fields and Waters program. This is a voluntary program that landowners can sign up for, and it allows walk-in access for hunting, trapping, and fishing in the state of Nebraska. And for this program, you would receive a payment between 50 cents and $15 per acre of land, depending on the location, what type of enrollment you selected, and the habitat quality. This program works really well with CRP, and CRP, they work together to find CRP that can be used for this open fields and waters program. This is a longer term contract between 1 and 15 years. And I encourage you, if you're not familiar with it, to reach out to Nebraska Game and Parks and learn more about this program. So that is the conclusion of our information that we have regarding lease agreements. I am going to ask Dave to help me address the question in the chat box, but if you have a question for Dave or I related to hunting leases, I encourage you to use the Q&A or the chat box to do that now. So Dave, the question in the chat box is, what is the liability when a hunter is trespassing on the property? So can you answer, what is the liability when a hunter is trespassing?
It's basically the least amount of liability that a landowner or a tenant in possession would have. There's some theoretical liability, to notify them of known dangerous hidden conditions. However, if somebody's a trespasser, a jury is not going to be very sympathetic if they get themselves into trouble while they're trespassing. So while we're talking about trespassing hunters, I would also just throw out there, if you've got trespassing hunters and you want them gone and you're not comfortable taking that task on yourself, I would contact either local law enforcement or local game and parks enforcement if you have them, if they have some that are close. But if they're trespassing, if they're hunting without permission, it's clearly a trespass, and so it's not anything that you have anything to put up on. That you need to put up with. But if they're all carrying AK-45s and stuff like that, you might want somebody else to be the ones to get them off.
Is there anything in regards to posting no trespassing signs in Nebraska that we should be aware of, Dave?
One thing that was around back in the 80s was a sign that says no hunting without written permission. So if they can't pull out that written agreement that says, yes, I have permission to hunt during this period, and here I am, if they don't have that, that is automatically trespassing, and you don't have to, it makes proof a lot easier because they don't have the written permission.
So again, I would encourage you, if you have any questions, to place them in the Q&A or the chat. Dave and I will hang on for a few more minutes to answer those questions. Just as a reminder that a recording of this webinar will be posted at cap.unl.edu, where you can also register for our other upcoming webinars. Here in just a minute also, we will be placing a brief evaluation in the chat box. So if you want to click on that link and make sure that you tell us about how today went and inform us of future webinars. So giving you one last shot to post your question.
Jessica, I'm not real familiar with the Game and Park hunting regulations. And I don't know what kind of restrictions they have on the weapons that are appropriate for different seasons and stuff like that. But that's one thing that I would definitely talk with the attorney about, especially if you wanted to keep automatic weapons out. That certainly would be something that you would put in your written lease. And again, that would be something that if I were a landowner looking at this situation, that I would certainly visit with the attorney about, because that's, poses all kinds of, unnecessary risks, in my opinion. So just throwing it out there for what it's worth.
Absolutely. Absolutely. Well, I'm not seeing any more questions in the chat box or in the Q&A. I want to thank everyone for joining us today, and we look forward to seeing you on a future Center for Ag Profitability Thursday webinar. Thank you for joining us.